There are no facts to dispute before this court. I see no evidence that has the needed personal subject matter jurisdiction. The state is a fictitious plaintiff. The state of isn't here to testify. No injured man or woman is present before this court to provide firsthand knowledge. I am acting as surety for the named principal to contest jurisdiction. I am aware this is a taxable event and an excise tax is owed, and I want to be in compliance with the IRS code.
Probation will be a waste of time in this matter, so I will revoke and remand you to serve your sentence. Take her into custody.
All right. $1,200 every minute I'm in jail.
It sounds like you're describing a classic case of someone trying to navigate the legal system without proper guidance. The whole scripted approach could definitely be true. People often look for solutions when they feel overwhelmed, even if those solutions aren't credible. Whether she truly believes it or just repeating lines, the outcome is often pretty chaotic. What specific things did she say that made you think that?
Your Honor, this comes before the court today on a probation violation hearing. And it's the intent of the defendant at this time to stipulate. And I do believe there's a agreed sentence, as you would say in this case.
All right. Ms. Clark, you've heard the announcement of your attorney. Is that what you want to do? Admit to the violations?
No, actually, I'm going to make a motion for my attorney to withdraw. I got this myself.
Oh, okay. What's the reason for that?
I just want to represent myself.
Okay. All right. Well, somebody give her a waiver of attorney form. Okay. It's muted for some reason. All right. Well, I've already gone over these rights with you, so you should understand them, but you have the right to hire your own attorney. If you can't afford to hire an attorney, I've already appointed one. You qualified. You do have the right to represent yourself as well, and that's what you want to do today?
Yes, sir.
All right. If you want to waive your right to an attorney, when we do this, you have to follow the rules of procedure and evidence just as if you're an attorney. You understand that?
Yes, sir.
All right. Has anyone promised you anything or threatened with anything to get you to waive your right to an attorney?
No, sir.
All right. Looks like you've already signed it and sent it in here. Did you understand this form you signed?
Yes, sir.
I'll accept your waiver and allow you to represent yourself. All right. Are you wanting to stipulate to the violations, or do you want a contested hearing?
I'm going to contest it.
All right. Mr. Hollis here.
Yes, Judge, I can grab him real quick.
Okay. Okay. State has the burden. Any opening statement, Mr. Marcinski?
No, sir. Thank you.
All right. Ms. Clark, any opening statement?
No.
You're right. Passing on an opening statement is a huge missed opportunity. Like you said, it's your chance to establish your defense and speak directly to the judge, especially when you're representing yourself. While skipping the sovereign citizen speech might be a relief for some, it doesn't make the strategic blunder of forgoing an opening any better. It essentially gives the prosecution's argument unopposed ground. I'm curious what you think the thinking behind that was, if there was any strategy to it. What's the next stage in the case now?
All right. State may call this first witness.
Thank you, sir. The state would call Court Service Officer Christopher Hollis. Sir, will you please state your name for the record?
Chris Hollis. I'm a court services officer.
In that job occupation, were you assigned the supervision of a Miss Ashley Clark? That supervision being for an endangering a child underlying 12-month sentence?
That is correct.
On May 18th of this year, 2023, did you test Miss Clark for the presence of drugs?
Yes.
And what was the result of that UA sample for Miss Clark?
It was positive for methamphetamine.
So her UA was positive for methamphetamines, and she also, in response to that positive UA test, signed in a statement of admission of using methamphetamines?
That's correct.
Did you order her to report on June 2nd, 2023?
I did.
And did she appear on that day?
She did not.
Has she appeared or reported to you since that time?
No.
Sometime after May 24th of 2023, were you advised by local authorities of her being arrested for a new crime?
Yes, and I did. I received that, and apparently she has new charges.
To your knowledge or to the notes, did Ms. Clark ever report that negative law enforcement contact with your office?
No, she did not.
That will be my questions for Mr. Hollis at this time, Your Honor. Thank you.
All right, Ms. Clark, do you have any questions for Mr. Hollis?
No.
All right. Do you have any further evidence or witnesses, Mr. Marcinski?
Not at this time, Your Honor. I do not.
All right. Ms. Clark, you have time to, now it's your turn to present any evidence if you want to. Do you wish to present any evidence?
Right now, I see no evidence. This has the needed personal subject matter jurisdiction.
If you want to present any evidence, do you want to present any evidence?
No.
It seems like you're catching on that tension between feeling awkward for her and also understanding that she made a choice about legal help. That decision to go solo in a serious setting definitely perplexes a lot of people. Watching someone navigate something complex without assistance can be tough to watch, regardless of why they're there. Are you thinking about the psychological reasons for a choice like that, or just reacting to the moment itself?
No? Okay. Well then, closing argument, Mr. Marcinski?
Your Honor, at this time, the state believes it is shown by a preponderance of the evidence that Ms. Clark is in violation of her probation and conditions of probation imposed by the court therein. The state's going to ask that you find that she is in violation of that probation. The state would point out that this is a misdemeanor probation for endangering a child. Therefore, Ms. Clark is entitled to no graduated sanctions, intermediate sanctions, or other relief set forth by the legislature on felony probations. Due to the litany of violations, the continued drug use, the failure to follow through with her treatment requirements, the state believes that she's shown that she's not amenable to probation and would recommend the court revoke and remand her to serve her underlying sentence.
All right, Ms. Clark, closing argument?
There are no facts to dispute before this court. I see no evidence that has the needed personal subject matter jurisdiction. The state is a fictitious plaintiff. The state of isn't here to testify. No injured man or woman is present before this court to provide firsthand knowledge. I am acting as surety for the named principal to contest jurisdiction. I am aware this is a taxable event and an excise tax is owed, and I want to be in compliance with the IRS code.
Okay. It'll be the order and judgment of this court. Well, first of all, I'll make my findings. The state's shown by preponderance of the evidence that you violated probation in this case using methamphetamine around the 18th, as evidenced by the 18th of May this year, as evidenced by the positive UA and the admission. Also find that you failed to report in violation of probation as alleged. That would be the June 2nd, 2023 date. You failed to successfully complete outpatient treatment at Summer Mental Health as ordered by the court, so I find you violated probation there as well. You also failed to report law enforcement contact within the business day in violation of the orders of probation. You have violated, it does in a very substantial way. I will go ahead. It appears as if probation will be a waste of time in this matter, so I will revoke and remand you to serve your sentence, take her into custody.
All right. $1,200 every minute I'm in jail.
This courtroom is about to get out of control. Wait, did she seriously just suggest she should be paid $1,200 for every minute she spends in jail? That level of delusion is unreal. This is someone who violated probation, continued abusing drugs, and even put her child at risk, yet somehow believes she deserves compensation instead of consequences. That's beyond disconnected from reality. And honestly, after hearing that, any sympathy completely disappears. When you break probation and endanger a child, jail time is the result of your own actions. If anything, incarceration should be the least of your concerns at that point. On top of that, let's talk about the disrespectful remarks she made before being arrested. Maybe it wasn't a direct threat, but it crossed a serious line. Speaking to a judge like that with sarcasm and attitude is never going to help your case. This whole pay me for my time argument fits perfectly into that fantasy mindset where some people think rejecting the court's authority means they can invent their own legal system. That's not how reality works. The state isn't going to reward someone for serving a sentence caused by their own behavior. She's not being mistreated by the system. She's facing the outcome of her own decisions. The only thing waiting for her right now is the sentence tied to those choices. All right, guys, now that we've watched this courtroom train wreck unfold, I need your thoughts in the comments. Does she have any possible way out of this situation, or is this game over for her? And seriously, does anyone think she's getting that $1,200 per minute? Absolutely no chance. If you enjoyed this breakdown, make sure to like, subscribe, and I'll catch you in the next one. Stay safe, everyone.